start. These applications have been filed in the second appeal admitted by the division bench on July 12, 2002, full stop. The first application, CAN 1238 of 2014, is at the instance of the respondent number 1, the defendant number 1 in the partition suit, for recording the abatement of second appeal on the ground that 4 respondents have died and their respective legal representatives have not been substituted in the appeal, full stop. The second application, CAN 4204 of 2014, has been filed by the appellant praying for setting aside of the abatement of the appeal against the deceased respondents after condoning the delay and a direction upon the surviving sole respondent to furnish the names and addresses of the legal representatives of the respective deceased respondents, full stop, para. The appellant, a stranger purchaser of a portion the suit property, in the bracket, jointly owned by the ancestors, respondent numbers 1, 2, 4 and 5, bracket close, filed the suit claiming partition of the suit property, full stop. The respondent number 3, since deceased, also a stranger purchaser of a portion of the suit property, was the defendant number 3 in the partition suit, full stop. In the partition suit, the defendant respondent number 1 filed an application claiming a decree for preemption against of both the stranger purchasers, full stop. The learned trial court rejected the claim of the plaintiff appellant for partition and allowed the prayer of the defendant respondent number 1 for preemption against both the plaintiff appellant and the defendant respondent number 3, since deceased, full stop. However, the learned trial court did not declare the shares of respective shares of the partition suit, full stop. The plaintiff appellant filed an appeal against the judgment and decree of the learned trial court before the learned first appellate court, full stop. By an order dated September 10, 1990, the learned first appellate court set aside the judgment and decree passed by the learned trial court and remanded the partition suit to the learned trial court, full stop. In an appeal filed by the defendant respondent number 1, this court set aside the said decision of the learned first appellate court and directed the learned first appellate court to decide the appeal on merit and ascertain the shares of the respective parties to the partition suit, full stop. By the impugned judgment dated December 20, 2001, the learned first appellate court affirmed the judgment of the learned trial court that the suit property is the dwelling house of the family of the respondent numbers 1, 2, 4 and 5, and as also the decree of the learned trial court for preemption in favor of the defendant respondent number 1, full stop. The learned first appellate court declared the shares of the respective parties to the suit, para. From the cause title of the memorandum of appeal, it appears that the addresses of the appellant and the respondent numbers 3 and 5, since deceased, are the same, that is Village Patna, Police Station Polba, District Hooghly, para. In paragraph 4 of the application of the respondent number 1, that is CAN 1238 of 2014, it has been stated that the appellant is running his shop in a portion of the suit property, the respondent number 5, since deceased, was also residing at the suit premises and she died at the suit premises. The respondent number 1 further stated that the respondent number 3, since deceased also resided just opposite to the house of the appellant, Mr. S.P. Roy Chaudhuri, learned senior counsel appearing for the appellant in support of application for setting aside of abatement of the appeal, placed paragraph of the appellant's application submitted that the plaintiff appellant was not aware of the death of any of the respondent numbers 2 to 5. Stop.